Doctors, imagine this. You perform a routine surgery, the patient is discharged, and years later a legal notice lands on your desk. You're accused of medical negligence for something you don't even remember. Sounds terrifying, right? Well, this happened in the landmark Supreme Court case of Dr. V.N. Srikhanda versus Mrs. Anita Sena Fernandez, and it has major medico-legal lessons for all of us. In 1993, Dr. V.N. Srikhanda, a surgeon in Mumbai, performed a gallbladder removal. But guess what? A piece of surgical gauze was accidentally left inside the patient's abdomen. For 9 years, she had abdominal pain but didn't seek treatment. Then, in 2002, a CT scan revealed the retained gauze. She underwent another surgery to remove it. And here's the big medico-legal twist. She sued the doctor in 2004, 9 years later. This is a textbook case of res ipsa loquitur, a Latin term meaning the thing speaks for itself. When a foreign object is left inside a patient, negligence is presumed, and the burden of proof shifts to the doctor to prove they were not negligent. Now you may be thinking, why did the court even entertain this case after so many years? Isn't there a 2-year limitation under the Consumer Protection Act 2019? That brings us to legal issue number 2, the limitation period and discovery rule. Doctors normally, under the Consumer Protection Act, a patient must file a complaint within 2 years from the date of the cause of action. But the Supreme Court ruled that the limitation period starts from the date the patient becomes aware of the negligence, not when the surgery was performed. This is called the discovery rule. So even if you performed a surgery years ago, you're still at risk if the patient later discovers a complication that can be traced back to your procedure. This case teaches us some crucial medico-legal lessons. Let's talk about how you can protect yourself from such cases. Follow WHO surgical safety protocols, which says, always conduct instrument and swab counts before closing up. Document everything. Your operative notes should explicitly state that all surgical materials were accounted for. Use radiopaque gauze, which ensures that any retained material is visible on post-op imaging. Get signed informed consent, and patients should be made aware of the rare but possible risks of retained surgical material. Follow up vigilantly. Don't ignore post-surgical complaints. Conduct imaging if a patient has unexplained pain. Doctors, one mistake, one missed gauze, can result in a legal battle years later. Be proactive, practice defensive medicine, and always document meticulously. If you found this video valuable, hit the like button, share this with your fellow doctors, and subscribe to Dr. Lawyer Official for more medico-legal updates. And remember, stay safe, stay protected.